Now I want you to tell me why you forged her name to checks.
Because she asked me to do this.
She said to you, forge my name to a check.
Yes. She was saying she was going to put me in jail.
Have a seat, everyone.
Hello, Judge.
Hi.
Case number 2046, Rapp versus Hall.
Thank you.
You're welcome.
Miss Rapp, not a very difficult case. The defendant was a friend of yours / did some work for you. It's not really relevant how you met him. It was sort of through a social situation. And it is your claim that over a period of time, Mr. Rapp forged your signature to several checks.
Correct.
And then when confronted by the fact that you've discovered these forgeries and asked him for money, he filed a restraining order against you to keep you away from him, and you say that the restraining order was a false one, and you want to be compensated for having to deal with that.
I do. I missed work.
Just a second. So I'm going to deal with the restraining order first. When did you file a restraining order, Mr. Hall?
I believe it was the 17th of July.
Of this year?
Yes, ma'am.
So not so long ago. I'd like to see the paperwork that you filed in support, just the paperwork that you gave to the court in support of your restraining order. Why you were asking for a restraining order.
Okay.
Don't tell me. Is that what you filed with the court?
Yes.
I'd like to see. So let's just be clear. You filed all these documents with the court when you asked for a restraining order?
Yes.
Okay. Yeah, I've read some of the text messages, and you're aware of what the text messages say.
Yes.
I assume you're aware of what they say. Uncross your hands.
Oh, yes.
And that part of your application for damages as a result of filing a false restraining order is denied. You can't even suggest in a text message that you're going to do something violent in order to get him to pay money that you owe. Do you understand that?
I do.
Okay, so as
Although
frustrated...
the restraining order was dismissed.
It doesn't matter. I'm telling you, I've read it, and some of your text messages sound threatening.
I was angry.
I understand you were angry. The question is not whether he should be granted a restraining order. I don't have to deal with that. I have to deal with the fact that in the text messages, you make certain threats. What if I could? And all that transpired at a time when the defendant reconciled with his wife and family. So, as I said, as a result of reading your text messages, I believe that Mr. Hall had the right to feel threatened and to file for a restraining order. Whether the court that heard the application for a restraining order felt that your behavior warranted a restraining order is another thing. But I can understand why he would file a restraining order to try to keep you away from him and his family.
Oh, yes, ma'am. Sorry.
Great! Now I want you to tell me why you forged her name to checks.
Because she...
$8,800 worth of checks. Now you have the right to file a restraining order.
Because she asked me to do this.
Because she asked you to forge her name to the checks.
Yes.
Okay, I want you to tell me when the first time she asked you to forge her name to a check. And I assume, just like you've kept all these documents.
Yes, ma'am.
You have a document to show me, just one. Because if you show me one, I would tend to think that there were more. So just show me one where she said to you, forge my name to a check.
Okay.
Take the money out and forge my name to a check. Don't say anything. Just show me. Don't shake your head. It's annoying.
I believe this is the first one.
Okay. So in that one, she asks you to sign. Well, maybe. What are you showing me?
The check.
I don't want to see the check. You know how you kept these text messages that you texted back and forth and back and forth? I want you to show me, because you're methodical, one time out of the 6, 7 times that you forged her name to checks, show me one time where she said to you in a text message, in an Instagram, in a pigeon note, where she said to you, take out a check from my checkbook and forge my name to it because I want you to have money. Just show me.
I don't have
Of course
like
not.
That. No.
Of course
No,
not.
I don't.
Now, the first time you forged her name to a check was what month and year?
I I believe that it was December 9th.
Of 2021.
Yes, ma'am.
And what were you and Miss Rapp engaged in at that time that she told you to forge your name to a check?
Okay, so I'm an electrician, and I've been an electrician for 13 years. I've been doing side work all around my county, and there's a handful of liquor stores that trust me that I can go and cash personal checks that I get paid for doing my side work. Miss Rapp knew that, and...
Don't tell me what she knew.
Okay, all right. So she would be locked out of her account for one reason or the other, and she would ask me, like on a Friday, she wouldn't be able to get access to her money, and I knew she had money.
Well, she couldn't get access to her money, so these weren't your checks you wrote out. You wrote out her checks. It'd
Right.
be frozen out whether you went to take out money or she went to take out money.
Right. Also, on a Friday, the liquor store would not deposit these checks until Monday. So I cashed these checks for her to give her cash.
Did you ever have sex with the plaintiff?
No.
Do you think she wanted to have a relationship with you?
I think so.
Okay.
I don't know.
What makes you think so?
Well, the
text message.
The text message.
The text message that she
Yeah.
said to you. And who is Robert?
Is her ex-boyfriend?
And do you know Robert?
I do.
How do you know Robert?
I'd known Robert for 20 years. Been friends.
And when did you start doing work for the plaintiff, before or after Robert? Is not an answer.
It was after.
It was after.
Yes.
Okay. Give me an idea of when. You've cashed the first check in December of 2021. Give me some idea of when you were aware of the fact that the plaintiff and your dear friend of 20 years were no longer an item. Is not an
I
answer.
don't know what
Month.
month he was arrested. So
Arrested for?
June, maybe?
Arrested for?
I don't know his charges.
I don't believe that.
Okay.
I want to see only with those forged checks, you would have put the money in her Venmo account.
Your Honor, I don't see where I have the ones that I deposited in her account. These seem to all be her depositing into my account.
Duh. You were happy she left.
No, ma'am.
You wanted her to stay.
No, ma'am.
To write the checks.
I'm just telling you, I don't believe that you don't know the charges of somebody who you were friendly with for 20 years and who was arrested. I don't believe that you don't know, because it
Okay.
belies credulity, okay?
That's fine.
So before your dear friend of 20 years was arrested, did you ever cash any checks for her?
No.
After Robert was arrested? Yes. Did you ever do any work for her before Robert was arrested?
No.
When did you and your wife separate? Month and year.
Maybe February of 21?
And were you still together with Robert in February of 2021?
Yes.
And when did you and the lovely Robert separate?
Robert was removed from my life August 11th of 21.
The defendant acknowledges in his answer that he forged your name, not only your name, your signature, but wrote out checks, actually wrote out in his own handwriting, checks in the amount of $8,800.
Yes.
And he acknowledges that, but he says they were because you asked him to, or it was for work he did for you. Those were your answers, right?
No, these checks were not for any jobs that I did for her. They were strictly to get access to some of her money during the weekends and stuff. And then when she was out of town as well.
Get her access to her money and when she was out of town.
When she was out of town,
if you cashed her checks when she was out of town, how did she get money?
I Venmo'd the money to her.
Okay, so that you have a record of, that you Venmo'd the money to her.
Yes.
I'd like to see it. I'd like to see it.
Here you go. Here's all the Venmo deposits. Her sending me
To
money.
her. No, not, just a second. Try not to confuse me. I'm an old person. I want to see only the monies, because she's going to show me the checks that you forged. And contemporaneously, which is a close period of time, with those forged checks, you would have put the money in her Venmo account.
On a couple of different occasions, yes.
Just a second. Just show me those cases. She's going to take out the checks that you forged. And those checks should coincide date-wise with the Venmo transactions. Am I doing that right?
Yeah.
Venmo.
Yes.
Your Honor, I don't see where I have the ones that I deposited in her account. These seem to all be her depositing into my account.
Duh.
Yeah. So
Okay.
I do have.
So let us understand this, Miss Rapp. Did you ever give him permission? The answer is yes or no.
No.
Did you file a police report?
Yes, I did.
You did. I'd like to see a copy of the police report.
I haven't.
Then we're in good shape. Mr. Hall, how many weekly payments did you make to her on Friday?
I have a list of that from.
From February.
This is from Mrs. Rapp in.
No, I'm asking you.
Yeah.
I'm asking you, how many payments did you make for writing these unauthorized checks to her?
Seven.
And what was the total amount of those checks?
$3,700.
Why in the world would you pay her $3,700?
If you could look in those messages, I was being. She was saying she was going to put me in jail for doing things.
For forgery.
Okay.
For forgery.
Right.
And you asked her not to.
Right.
And you said, I'll pay you back.
Right.
Right. I'll pay you back. Just give me some time. I have 2 kids to support.
Right.
Is that what you said to her?
Yes.
$8,800 judgment for the plaintiff. We're done here.
Please adjourn.
Well, I'm happy about the outcome because
I think it's bogus, man.
I really need the money.
Because she started all this craziness as soon as I went back to my wife.
There was never a relationship between the two of us.
After that, when she started doing all this, is when I went and filed for a restraining order.
He did that as a direct retaliation for the police report I filed.
She's gonna have to call somebody else for sure.
It's definitely time for a new handyman.
Just a casual note.
Yeah.
I have been with my husband, your grandfather, for almost 50 years. And we each have our bank account, and then we have a joint bank account. I have never either asked him or given him permission to sign my signature to a check.
Yep.
He hasn't never asked or given me permission to sign his signature on one of his checks. Now, we may ask each other, listen, it's busy, I'm going to go through these checks. We're making all these checks out to the doorman and to Christmas time and whatever, and then I'll sign them. Just doesn't happen. So,
Doesn't make sense.
right. And so what it is to any job that you do, whether it's a lawyer or a judge, you bring with you your own common sense and your own life's history. I hope that works, because I cannot imagine somebody saying, write out a check for yourself. I don't know you, we're not involved, we're not married, go help yourself to a check and write it out. I can't.
Case number 2029, McCray versus Onwaka. All parties, please step forward.
Brittany McCray is suing her former roommate, Lulu Onawaka, for a rental deposit, moving costs, and lost wages.
Miss McCray, you were looking for a room, and you rented a room in defendant's apartment. It didn't work out. You were unhappy. She was unhappy. You moved out. And now you want return of rent, deposit, moving costs, lost wages, and emotional distress. She also said, didn't work out. We didn't like each other. It just wasn't a good fit. So you were happy she left. That's either a yes or a no. You were happy she left.
No, ma'am.
You weren't happy you wanted her to stay.
No, ma'am.
Then you were happy she left.
No, ma'am. I wasn't happy she left.
Oh, let me see. Let's see. Okay, this is what you say. Brittany, that would be you.
Yes.
This is your answer. Was messy, played loud music, brought friends in unannounced, damaged the washing machine which flooded our apartment, and without consent offered to adopt someone's dog. After that, I let her know we weren't a good fit and would not be renewing her lease.
No.
Now, that's what you said.
We'll not be renewing the lease for the
No,
apartment.
no, no. Doesn't matter. I just read you something. I read you your answer. Now, does that sound somebody that was happy with their roommate?
I define happiness for myself. I've lived in co-living where I've had to live with people I do not like.
What?
And make it work is what
To you?
No, you are right, and that is what I wrote.
Absolutely. Well, then I don't know why you have a passive-aggressive attitude, because I'm
No.
the only one who's passive-aggressive. Then you were happy she left.
No.
Okay, well, you're ridiculous. Then you're a masochist. Somehow you want to live with
Probably
somebody.
I am.
You want to live with somebody who's messy, loud, floods your apartment, weren't a good fit, and yet you were happy with that. And I don't have to define happiness.
Yes.
I know that if I lived with somebody who was messy, sometimes loud,
Okay, so each is
we broke the dishwasher and flooded the apartment because they put regular soap instead of dishwashing soap into the apartment, then it sort of bubbles all over. Now, unless I was either married to that person or they were one of my family, I wouldn't be happy with them. If I had a tenant like that, I would say, oh my God, what did I get myself into? I want out of this.
Okay.
But you were happy.
No, I wasn't. I stand on that.
Okay, then you weren't happy.
Yeah.
Perfect. That's what I asked you. You could have saved me all this dramatics. All right, so there we go. You were living in a room.
Yes.
You paid a month's rent.
I did.
Okay, how much rent did you pay?
I paid $1,300 and a $300 deposit.
And you lived there for about a month.
I lived there for 26 days.
And things didn't work out. You had a big argument with her back and forth. And as a matter of fact, according to you, you left for a couple of days.
I did.
Yes, because you were unhappy there and felt threatened, felt uncomfortable, whatever
Very
it was.
much so.
So you left for a couple of days. And when you came back, what was your intention when you came back?
So-
No, look, not so. Look at me. You left because you were unhappy. You came back. What was your intention when you came back?
I never left because I was unhappy. I left because I was evicted from the property by the defendant.
Just a second. So you didn't leave the apartment after this disagreement?
Yes,
You did?
I did.
Okay. Where did you go?
I actually stayed with my friend.
So you left.
Yes.
On what date?
I left on June 1st.
You left the residence and stayed with your friend.
Yes.
And you stayed with your friend after the argument.
Yes.
Why?
I'm able to provide some backstory on
I don't need any
encounter.
backstories. I'm just trying to get to a mindset of why the two of you think that you have a lawsuit against each other. Why do you bother wasting your own time, wasting precious court time when you weren't happy in the apartment, you paid for a month's rent. Certainly, you're entitled to your security back if you caused no damage to the apartment. You lived there practically a month, and you're not entitled to any more money because she didn't give you 30 days' notice because you were just as happy that
She had
left.
abandoned properties.
What?
She had abandoned properties.
Okay.
She damaged the door, and I lost my deposit as well because of that.
Just a second. Damaged what door?
So,
No, just not so.
Okay.
Damaged what door? That's a door. An
door-
outer door, a door to her room.
yes,
The door to her room.
yes, she did that.
You have a photograph of the damage.
Yes,
I'd
I
like
do.
to see it.
Please bear with me. I'm going to find it quickly.
The damage she's referring to was actually me attempting to change the locks on the door. I left after I had been informed by the
Just a
defendant.
second. So you acknowledge the door was damaged while you were trying to change the lock
I
on
was
the
trying
door.
to change the lock because during my time away, all of my belongings were still in the property. Correct?
Listen to me. Did you damage the door?
No. The doorknob was removed, but the door is not damaged.
The lock was removed.
The lock was removed.
All right, I'd
so
like
that
to see.
The defendant would no longer have access to my room, to which she actually did enter my room while I was away.
Okay.
I left because the defendant actually informed me that I would need to get out by that date. After requesting a full month of rent, despite me not having even lived in the property for the original month of rent that I had paid for.
I don't care. Unless you can show me the damaged door and how much it was to repair it, and I want to see how much it was to repair it.
I don't have how much it was, but here is the lease agreement, and we paid $2,900 to be here for the security
second.
deposit.
Oh, she just took this out. That's nonsense. That's
Ma'am,
nothing.
I wasn't still able to get my deposit
Nothing.
back.
The
I
agreement
got
that I...
$1,700 back.
Understand this.
Okay.
This is not damage to the door. She took out a cylinder. All you have to do is put it back. Unless you have a receipt for somebody putting it back, you get
No, but
nothing.
that's what I'm saying. We didn't put
you
it
get
back.
nothing.
We
You
didn't
get
put it back.
nothing.
It's a maintenance request at the property.
I didn't ask you a question. You're entitled to your $300 security back.
That wasn't the security. That was for key and cleaning, and she was aware of it.
$300 security deposit. By the way, are you allowed to sublet rooms in your apartment?
I
Hey,
wasn't.
that's a yes or a no?
No.
Just a, hey,
No,
hey,
no,
don't
I
look down.
wasn't. No, I
Don't look
wasn't,
down.
ma'am.
So
No,
the
I
answer
wasn't.
is you are not allowed to sublet
wasn't.
rooms in your apartment.
Yes.
Okay. Yes, you are not allowed to sublet rooms in your apartment. She gets her deposit back. We're done. Thank you very much.
No, hear me out.
Court is adjourned.
I didn't concede to her requesting me to clean out a garbage at the apartment, and at that point, she lost her entire senses and asked me to move out of the apartment. Always pick your roommates more carefully.
Later, between January of 2020 and September of 2020, did you meet with the defendant?
We did. We initially go ahead.
Tell me the dates that you met with him.
So the first meeting was January 10th when we signed the actual contract.
Where did you meet with him?
He came to our home.
Okay.
We signed the contract that day.
Okay. But you had contacted him the beginning of January when you first took the hall,
Yes,
the
ma'am.
venue. And then you said, well, come to the house. We'll discuss exactly what you're going to do. He did. Did he show you any photographs, any pictures?
He did.
Okay, so that took a while. How long was he there?
He was at the house maybe no more than 2 hours for the initial
Well,
meeting.
just a second. He was there for 2 hours. And you must have been satisfied because you signed this contract.
Yes, ma'am.
And that was January 10th. When was the next time you saw him?
I don't
When was
know
the next time you were there,
I
Mr.
saw
Sanchez,
him.
or the next time you saw the plaintiff?
After I went to her house, we went to the venue. It was February 25th.
You went to the venue with him?
Yes.
Okay, what did you do at the venue?
So when we went to the venue, we showed him the outdoor space and kind of our vision, and we talked through it and just talked about options and placement of flowers and just different options of draping and whatnot.
And about how long did that take?
Maybe about an hour as well.
It was more.
Did you see him again?
We saw him, or I saw him, I went alone, February 28th to do a mock setup.
Okay, and where did you
can
do
I
the...
backtrack before then? So we were initially going to get married in September. I contacted him literally 2 weeks after signing the contract to push the wedding up to March because my dad was diagnosed with cancer and we wanted to do it sooner rather
You
than later.
wanted to do it 6 months earlier.
Yes, ma'am.
You think you're entitled to $4,000 back. Well, what about all the time he spent with you?
I understand that time.
Just a second, I'm just asking you. He spent 5 to 6 hours with you. Is he not entitled to be compensated for that?
Kenesha Taylor claims wedding planner Carlos Sanchez wrongfully kept her deposit after a mandatory lockdown.
Okay, and the venue was free.
Venue was free.
And he was free.
He was free.
So that you had to get moving faster.
Yes, ma'am.
Okay, so now you contacted him. That I read and that I understood. So you contacted him again and things started to move a little more quickly because now he had less time.
Right.
And you met him again.
So the last
end
time
of
I
February.
actually saw him was February 28th.
Okay, on
when he did the mock setup.
Okay. And did he show you several different designs?
We did.
How many different designs did he show you?
There was 2 actual tables that he set up that he showed, and then in his showroom was the different options that he had for.
Just a second, did you go to his showroom?
I was at his showroom.
Did you go to the venue?
Not that day. We went to the venue once where we talked about looking at
Vision,
the
but
scheme.
this time you went to,
I went to him.
And he set up 2 tables with 2 different options consistent with what your initial discussion was at the venue.
Right.
Okay. And you selected one.
Right. And that's when I gave him the second deposit of $3,000 that day.
Okay, so the first deposit was $1,000.
Yes.
Second deposit was $3,000.
Yes.
In total, you gave him $4,000, which is what you're suing for.
Yes, ma'am.
Okay. And you think you're entitled to $4,000 back?
I think I'm entitled to $4,000 less the setup fee that he incurred, the actual fees that he incurred. That's what I was asking for.
Well, what about all the time he spent with you?
I understand that time.
Just a second, I'm just asking you. He spent with you probably at least 5 to 6 hours.
Okay.
In total, not including the setup fee that he did independently when you weren't there. He spent 5 to 6 hours with you and your husband. Is he not entitled to be compensated for that?
I would say yes.
Oh, yes.
But my question would be, again, it's not in the contract. I feel like he just kind of pulled a number out of the sky, just like he pulled a $500 contract fee out of the sky. Like, that was nowhere discussed. That was just kind of something he...
It's not discussed because nobody anticipated that if you were supposed to be married in mid-March...
Well, late March, but yeah.
Late March. And on March 15th, the state was shut down and you couldn't have a wedding. The venue itself hadn't done anything for you other than hold the date.
And a tasting. We did a tasting with the venue as well, but yeah.
You did a tasting?
With the venue.
Did they charge you for that?
They did not.
Did they give you back your full deposit?
Yes, ma'am.
That was very nice of them. Did you have a wedding there ultimately?
We did not.
Well, it was very nice of them. They did a tasting. It's a big operation, but there's a certain amount of work that he performed. You know, how do I explain this to you? If you go to see a dentist and the dentist is performing a whole procedure to put in a crown. In order to do that, there are procedures. They have to first sometimes do a root canal, then they may have to shave down a tooth. And let's say the patient dies before they can get the crown put in. Does that mean that the dentist doesn't get paid for all the work that they did?
No, absolutely not. They'll bill.
Okay.
I get it.
So he did work. And what you want to do is you want to put a value on his hourly time. You're employed?
Yeah.
Are you paid by week, every 2 weeks, by the hour?
I'm a salaried employee, but I get paid every 2 weeks.
Okay. And how much do you make approximately per hour?
About $70 an hour.
And what kind of work does your husband do?
He works for the oil refinery.
And is he a salaried employee bi-weekly or is he by the hour?
He's hourly.
And what's his hourly wage?
He makes about $45-50 an hour.
How much do you make an hour so you know exactly?
42.
So here you have two people. You make $70 an hour. He makes 42. There are lawyers who charge $600 an hour for their work. Mm-hmm. And there are lawyers who charge $1,500 for their work. They're both lawyers. Mm-hmm. You're allowed to set a rate. Once this contract is no longer in existence and there's an impossibility, in this case, it's not your fault or his fault. It became an issue of impossibility of performance. Mm-hmm. And then it's up to us to try to find a reasonable, since it's impossible for either one of you to perform ultimately the contract, he's entitled to be paid for the work that he actually did for you. That seems only reasonable and fair, and that would come under a theory of quantum meruit. How much is it worth? Mm-hmm. So how much did he offer you as a refund?
$2,940.
Is what he gave you back?
No, he gave me nothing back. This is what he offered me in the form of a coupon.
Just a second. He offered you $2,940 back, which means that he was charging you $1,000 in effect for all the hours that he spent in the work that he did.
Not necessarily. It was a breakdown. So the deduction was $500 contract fee that he implemented. It was 4 hours of his time times $70 per hour. And then for the actual setup, it was $280 that he was actually out of pocket for the setup that he did on the 28th. And so the $2,940, again, wasn't even in the form of a refund. He said these were coupons that could be used back in his business at 3 different times.
If he offered you $2,940, that would seem to be a reasonable figure if he offered you $2,940 back in cash, because you paid him in check.
Right.
Do you understand that, sir? That would seem to be reasonable.
I understand.
Okay. Where are the contracts with the table companies, the chair companies?
They are my tables.
Oh, then you're not entitled to that. Is not an answer. I want what else you did. If you did something else, tell me.
Kenesha Taylor is accusing wedding planner Carlos Sanchez of keeping her deposit. Carlos says Kenesha refused his offer to reschedule the wedding.
If he offered you $2,940, that would seem to be a reasonable figure if he offered you $2,940 back in cash, because you paid him in check.
Right.
Do you understand that, sir?
I understand. I offer her a credit for...
No, we're not a credit. You were out your time and whatever actual money that you spent setting up the tables and showing her what the venue might look like. You're entitled to that. But no one knows how long COVID is going to impede the ability of someone to have indoor gatherings. So you are unable by law to perform this contract. Do you understand? You're unable by law to perform this contract. She is unable to do her part and pay you to perform this contract. So in my judgment, you are entitled to a certain amount of compensation for the work that you did. The venue, with the exception of giving them a tasting dinner, did nothing. It didn't buy food. It didn't spend any time with them other than the initial showing the venue. And venue, you signed the papers, and then you went for a tasting. And it opened itself up so that he could come in and look at the venue, which is nothing. They were out no money. They bought nothing. They really didn't spend a lot of time with you other than they would with any customer, just as the first time you spoke to him. The second time he came to your house when you discussed things and he spent 2 hours there, he's entitled to be compensated for that. And you're compensated at the rate of $70 an hour, right?
Yes, ma'am.
So let's say he's entitled to be compensated the same as you are. Reasonable? 6 times 7 is $420.
So wait, Judge, but he said 4 hours. In the initial one, he said he only spent 4 hours with me, and that was in his reply to me.
I'd like to see it. Even you said he spent 5 hours with you.
It was a rough guesstimate.
Well, but I'm telling you, you said you spent 5. Okay. So you made flower samples?
Yes.
Representatives times $70 an hour. Look at that. Times 4 is $280, and the flowers were $190. And want to tell me what company contract means of $500?
Other were obviously reserved the tables, the letters, and also the
Well,
flowers.
show me.
Yes.
Show me. You already have the flowers down here.
Yes.
As 190. You're getting credit for that. So far, we're to 470.
And-
I'd like to see what you did to reserve. Where are the contracts with the table companies, the chair companies?
They are my tables.
Oh, then you're not entitled to that.
No. Well, okay. Can I say something?
Yeah.
Okay. When she canceled it because for the COVID, it wasn't.
No, she didn't cancel
Well-
it because of COVID. The contract that you rendered was unenforceable by law. It was unenforceable. Based upon her figure, it was a little bit more than 4 hours that you spent with her. But you're not entitled to making a contract with yourself. I mean, if you engaged in contract negotiations with other vendors for chairs or anything else, I would consider that. But so far, you didn't. So the contract was unenforceable, and based upon your own statement to her, the time that you spent was 4 hours. You're entitled to that at $70 an hour, which is exactly what you earn. And flowers that you put together were $190. So that together is $470. And therefore, you should return to her $3,630. Is not an answer.
No.
I want to know what else you did. If you did something else, tell me.
We make sure that table and the letters that she wants for her table, and also.
Those are your things, you said to me. That's your property.
But we didn't sell it to another person because
You couldn't
we already.
sell. You couldn't
we didn't
sell it.
rent it. We
You
didn't
couldn't.
rent it.
You couldn't sell it to, or rent it to another person because everything else was closed after March. Everything else was closed. You couldn't rent them to anybody else.
Of course, no.
Of course not. Okay. The cancellation of these events brought havoc on the venue business for well over a year, probably still is. As I said, you're entitled to be compensated, and I certainly would not give her back her $4,000 because that would sort of be like her missing a week's pay if they closed the plant where she was working. And she would say, well, I was here, I'm ready to do my job. And the plant would say, listen, this is COVID, but I actually came to work every day. I drove there every day. I did work from home. I expended time. She would want to be paid. You're entitled to be paid. But by your own analysis, what you're entitled to be paid was $370. And so she gets her deposit back, less that $370. Thank you. We're finished.
Thank you.
Court is adjourned.
I'm happy. I agree with her. I think it was very fair.
I don't think it's fair. Everything with the COVID, our company, it was very difficult. And
I tried. I sent texts, I sent emails. I had a lawyer send a demand letter to try and resolve it before we got here to no resolve, but I'm happy.
to get back money right now is very difficult for our company and obviously myself.
Time to live happily ever after now.
I'm going to change that contract to be more clear.
So although it wasn't my best class in all of law school, one thing I do remember from contracts is the importance of a force majeure clause, where it allocates the risk of loss if something unexpected happens at no fault of either party. And in this case, they really could have benefited from a clause such as that because they could have stated who was going to pay, what the refund was going to be, how much she was compensated for time if the wedding did not end up happening. So I think that it's important that you really review your contracts before signing them.
Yeah, I agree with you. I didn't actually think of force majeure. That's exactly what it is. It's a major force that precludes either party from performing the terms of the contract and defining what their responsibility is, if any, if something prevents the contract from going forward. Interesting.
Have you been cheated? Go to judyjustice.tv.
After the breakup, he vandalized both your house and your car.
Yes. He does a lot of drinking. He was drunk. Got to the point where yelling, I'm done. I'm going to my mama's house. I can do what I want to do.
And you just left.
Yes. I was escorted out by the police.
Well, that's not a just left.
This is Judy Justice. Danielle Lovett is suing her ex-fiancé, Mario Griffin, for vandalism and emotional distress.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 1078, Lovett versus Griffin.
Thank you.
You're welcome.
Ms. Lovett, from what I read from your complaint, it is your allegation that the defendant, who was your boyfriend and for a period of time you lived together, after the breakup of the relationship, he vandalized both your house and your car. That's what you're suing him for.
Yes.
The defendant sort of acknowledges that he lost his temper once and he broke some windows in your house. He acknowledges that he did it, and he said he paid you $400 for the broken windows. As far as the other things are concerned, he denies that he caused any damage whatsoever to your car. And he says, in addition, when you were living together, he purchased certain items for the house. He is no longer in the house, and he wants those items back. In addition, he says that you filed a false police report against him, which we'll get to in a moment. That's what the case is about, so you have a counterclaim.
Yes.
So I need some dates from you first. Tell me the month and year that the two of you moved in together.
It was September 2017.
Did you move to his apartment? Did he move to your apartment? Or did you move into an apartment or a house together?
We moved in together.
So you found an apartment together. Where had you been living previously?
He was staying with his mom, and I was staying with mine.
And in 2017, when you moved in together, was the lease in both your names or in one name?
Mine.
Is there any reason for that? I mean, it's a very good idea and one that I support, because if things don't work out, then somebody knows they have to go, rather than it being a joint lease that you're both involved in.
Okay, well, with his background, he wasn't eligible to get on the lease. He couldn't pass a background check.
Okay, is that correct?
Yes.
So, Lisa, and you're still as a couple living in this apartment when the breakup took place?
Yes.
Okay. And the breakup took place what month, day, and year?
January 25th. 2021.
And it was not an amicable breakup, so he left quickly.
Yeah, he still had time to get his thing.
Okay. Had you discussed breaking up?
No, he just left on his own.
On January 25th, tell me what happened. She said you just decided to leave.
January 25th, we did have some issues. I'm a truck driver, so I'd be over the road driving trucks, and Danielle would call me while I'm over the road disturbing me, asking me if I'm on the phone with females, asking me...
Okay, so she's being jealous.
Yes.
Okay.
And like I say, it was a big distraction, and it's kind of frustrating because I have to focus on this road.
Okay. I got it that you didn't want a distraction, but you've been together now 4 years and living together in the same place for 4 years. I'm asking these questions, and there's a reason for it based upon your counterclaim, sir.
Okay.
You planned on leaving?
Well, we talked about it. We had some conversations, and I was like, this is not working. And
on what date did you tell her that it wasn't working?
January the 25th.
Is that when you came home from a job?
Yes.
So you were at home?
Yes.
And you just left?
I was escorted out by the police.
Well, that's not a just left.
Right.
I mean, I don't remember because I'm old, but, I've been in various relationships, but I don't remember ever calling the police to escort somebody out.
Well, that was the plan, to me to just leave like that, but she got mad and she felt like I was grabbing some of my things, and she called the police and lied.
Okay, just a second. So that the plaintiff called the police?
Yes.
Miss Lovett, on the 25th of January, do you want to tell me why you called the police?
The 25th of January, the police wasn't called. We had been arguing previously, and on that day, he does a lot of drinking. He was drunk, and he just decided to, start with me. It got to the point where neighbors worrying about what's going on. He left. He got his things, he left. He told me to keep whatever, don't worry about nothing. I'm done. I'm going to my mama's house. I can do what I want to do.
Okay, so he left and he said, I'm going to my mother's house.
Yeah, that time the police was not called.
When were they called?
It was the previous time before that in 2020. That's not when the police was called. He left willingly.
Sometimes people need their recollection refreshed. Does it refresh your recollection, sir, that the police were called in the year 2020,
yes,
not January 25th, 2021, when you just left?
But also then.
You have any proof that they were called that day?
No, I don't have any proof, and I can also say they was called again on May 25th.
Okay, but you said you were leaving.
Yes.
And between January 25th and May of 2021, did you and the plaintiff have any contact?
Yes, I actually moved back in.
When?
End of February, March.
Is that right?
Yes.
So we took a breather?
Yes.
And you took him back?
Yes.
And that didn't work out, and there was an incident in May.
Yeah, it'd be a lot of incidents.
Oh, yeah, well,
So
just a
in
second.
May, we're not just,
Wait, wait, 1 second.
He only brought a mattress back, not the box spring. He sold the mattress to his friend last year for $50.
Well, I cannot believe I went to 10 years postgraduate school for this.
Yes.
My father would be proud.
Later,
there was no agreement or understanding from the very beginning to the time he sold the house behind my back that he had anything to do other than live in the house.
Smothers,
Yes.
let me read to you what you wrote in your sworn complaint.
Danielle Lovett claims her ex-fiancé, Mario Griffin, vandalized her car and caused emotional distress. Mario is countersuing his belongings and an assault.
Is what you're saying to me, Miss Lovett, that between January 25th, you and the defendant continued to have contact, and he moved back in at the end of March of 2021?
Yes, he moved back in March.
Until when?
March till August 3rd.
Well, then I'm confused, and I'm confused because of this. You claim in your complaint that the damage you're complaining about happened on February 11th.
Yes, he left.
Just a second. And then, after that damage to your windows and or your car, you resumed living together in March.
Yes, that's when he came back.
You
March.
continued living together for several months.
Yes.
Sleeping together.
Yes.
Eating together.
Yes.
Socializing together.
Yes.
Then, quite frankly, I don't care what happened in February. And neither does any court care what happened in February. You two were keeping house. There's a word in the law called condonation. And that means that if something happens between a couple and they have a fight and a spat and they break things and they call each other names and they call their in-laws names and then they go back to living together as a couple, the courts don't care about it. Because you evidently didn't care about it. You didn't care about it enough not to resume your relationship with him. So quite frankly, I don't care. And I'm not going to assist you in fixing things that he may have broken, that he may have done while you were separated if you took him back and you continued to live together. So your case is dismissed. Now, I'm going to get to the counterclaim. That's easy. Did he buy the following things? A deep freezer.
We purchased together.
Is that correct?
No.
Prove to me that you purchased it alone.
I have the receipt here, and it's paid for with my bank account. And,
Okay, I'd like to take a look at it.
Okay. Here's the receipt, the treasure chest and receipt. The system.
Now, what was purchased at Home Depot was $151.80. And do you have the receipt for the surround sound system? That's either a yes or a no.
No.
Okay. Do you have a receipt for a sectional sofa?
Yes, I have.
I'd like to see it.
Okay, I'll take that there. And this just, because I financed it, but it's a paper in here that just says paid in full. That one's, yeah, that's the one that said paid in full.
What is this? This is a lease to own.
Right, it's just a paper up there that says paid in full, 0 for the amount of the furniture, and sectional in a queen size bed.
Okay. And this was 15th of December of 2017.
Yes,
This is a
that was
customer
paid.
receipt.
Yes.
Well, let me ask you the following questions before I go through these things. So this is all old stuff.
Yes.
Okay. And the iPhone that you say you bought her, you say you bought her and then you turned off service,
Yes.
which is you have every right to do. And in what year was the iPhone 11 purchased?
The iPhone 11 was purchased 2021,
In what month?
March 27th.
When you moved back in?
Yes.
No.
Okay. Did you give it to her as a gift?
No, I have a business account, and by me having a business account, I'm able to business phones, and so I said, hey, I can get an extra iPhone.
Great. All right. You have your iPhone?
Yeah,
Great.
I still have it.
Great. Great. Did you put it on a new payment plan?
I switched
That's
my
either
phone
a yes
number
or a no.
to it. I can't do anything with it. He cut it off, took my phone number,
Just
and
a second. So you can't do anything with it. Well, he's not going to pay for it. So now you have it, frame it. I don't know what you want to do with it. Okay. When you lived together, did you have a joint bank account?
no, we did not.
Okay. Can you tell me, I have just a couple of bills. One is for a 4-year-old bedroom set, which I know that the two of you used, and one is a receipt for $151.80 for a deep freezer. He says he paid for it. You said we purchased it. Explain that to me.
I gave him like $50 on it. We purchased it together as far as the deep freezer.
What about the bedroom set?
The bedroom set, he moved out. I have a receipt where I purchased my own furniture set right here. He brought his back. His is broken. His bed, he sold. He brought a mattress back, not the box spring. He sold the mattress to his friend last year for $50. So the bed isn't even there.
I'm not following you. When did you buy a new bedroom set?
I bought a bedroom set because he moved out once and he took what he bought. So this was January 2018. I bought a sectional and a bed. He brought his back broken.
Just a second. So you were living together in 2018 and separated for a period of time? Is that what you're saying?
Yes, yes.
And when you separated back in January of 18 for a period of time, because I gather this was a back and forth, you're saying he took his bedroom set with him?
Yes.
And you purchased another one?
Purchased another.
Is that what you're saying? Does that have a ring of familiarity to you?
Your Honor, when I moved my furniture out and bedroom set out at the time, in January,
yes,
we end up getting back together, and it's a 2-bedroom apartment. And she bring the furniture back, bring everything back, bring the TV back, all this and that. We back together. So I bought all my furniture back. I bought everything back to the apartment. She did purchase another bed and another furniture set
that
section.
The two of you used together?
Yes.
Okay. Well, then let me ask you this. So what you're telling me is that the bedroom set, which is really the only thing I'm interested in, I'm not interested in a 2-year-old freezer that cost $100. The bedroom set that you purchased was in the second bedroom?
No, it was in our bedroom.
And what did you do with the one that she purchased?
In the second bedroom.
Oh, I cannot believe I went to 10 years postgraduate school for this.
Yes.
My father would be proud.
You sold the house for $27,000, and then the next buyer sold it for $108,000. I feel like you stole that whole amount. It wasn't your property to sell, and if you sold it, you should have at least told me before you bought another house.
Are they getting it out of their system? Yeah?
Danielle Lovett accused her ex-fiancé, Mario Griffin, of vandalizing her car and harassment. Mario claims Danielle refuses to give back belongings he purchased.
Let me put it to you this way. Do you have any of his bedroom?
Nothing is there.
Nothing is there?
Nothing.
She has nothing?
Not bedroom.
She has nothing?
She's lying.
Okay.
No bed. Couch is there, broken.
Just a second. The couch is there that he purchased?
Yes.
And it's in your apartment?
Yes.
Great. So you have 5 days to get it out. Do you understand? Okay. If you don't get it out of her apartment with a mover within 5 days, on notice to her as to what day you're coming, you will have considered the sofa abandoned. Do you understand?
Yes.
Yes. Okay. Perfect. Then I have resolved this case. Your claim is dismissed because of the reasons that I stated. You have my judgment. Do you understand?
Yes.
Perfect. Thank you.
Court is adjourned.
Well, it wasn't fair because he did the damages, but he's still going to pay for it.
I kind of think it's a money thing, you know.
You know, whether we get back together, he still did it, so that was not fair at all.
I'm a truck driver, so I make a little money and...
He could kick rocks.
She could use it for her benefits, you know.
He's a narcissist. He could find the next victim.
Glad it's over with, and hey, I'm gonna move on, you know. That's basically it.
So can you just explain a little bit why, if he did damage the home or the car while they were together, is getting back together enough of an out for him to not be responsible for that sort of damage?
Well, I took a term that I learned in law school, which is called condonation. And when you sue for the damage that your mate, your spouse did during the course of a marriage, you may use a course of conduct as a reason for a divorce. But courts can't go back and rewrite history. Now she's going back 6 months and say, well, he broke the windows in my house and he smashed the window in my car. Well, evidently you weren't upset about it enough not to let somebody who had that propensity back into your life and back into your bedroom. So, you know, there's a good lesson for everybody, especially for women. Leopards don't change their spots, usually. Anyway, condonation. Be smart.
Case 1088, Smothers versus Smothers. All parties, please step forward.
John Smothers is suing his twin brother, Chad Smothers, for his portion of profits from selling a house.
Mr. This is your brother. It is your claim that he owes you your share of the profit from flipping a house.
Yes, Judge.
I read your complaint. I read the answer. And it appears that you purchased 2 houses at auction.
Yes.
In what year did that take place?
2012.
And the purpose of purchasing the houses was for you and your brother to refurbish them and sell them at a profit.
Yes.
Okay. Do you have a written contract with your brother?
I have no written contract.
So this was an oral agreement with regard to real estate?
There was no agreement. I bought the houses. The only reason he came to the auction was to put the house in his name.
Justice, listen, you put the houses in his name. The houses are in his name. That means he owns them. If you say there was no agreement between the two of you to flip these houses, which I actually thought you said there was, then houses were purchased in 2012. They were put in your brother's name, so he owns the 2 houses.
Your Honor, we did have an agreement. We agreed we worked together on the 2 houses together at the beginning, and one would be his and one would be mine.
That's not the agreement whatsoever. I bought the houses for me and her to keep living one and eventually sell the other one. He had nowhere else to live. He had nowhere to go, lost his job. So he moved into a house that was, for all intents and purposes, unlivable. There was no agreement or understanding from the very beginning to the time he sold the house behind my back that he had anything to do but other than live in the house.
Smothers.
Yes.
You're the complainant, Jay Smothers.
Yes, John.
Let me read to you what you wrote in your sworn complaint. Chad is my identical twin brother. I was in the military, and when I was done, I lost my home. I was good at building and renovation, so I had the idea to start buying cheap properties, fix them up, and then flip them for profit. That's what you wrote. That's your signature. First time I did this, I went to an auction with my children's mother and Chad. That would be you. I had to put the houses in my brother's name in order to avoid some pending erroneous liens. I bought the 2 houses. I was going to live in one, and Chad and I were going to renovate both properties. That's what you said. Were you mistaken when you said that?
No, I was not mistaken.
Think about what you just said and what I just read to you that you wrote in your sworn complaint.
The houses were purchased for my plan, my idea. He had nowhere else to live. Yes, I eventually, when he moved into the house, I agreed that if he's going to live there and do work on it, with no rent, no payment, no nothing, that he would be able to eventually, when we sold the house together, that, yeah, he would get some of the money, but it wasn't his house to sell. It was my money, my plan, my investment. He just put his hand up during the auction.
He put $2,700 into the house.
Keep going.
And I made it worth enough to sell.
You sold the house for $27,000, and then the next buyer sold it for $108,000. I feel like you stole that whole amount from me. It wasn't your property to sell, and if you sold it, you should have at least told me before you bought another house. You bought a whole other house and didn't even tell me, and I found out through a friend that you have this money now and didn't even give me a single nickel off of it. Now, maybe we have an exact agreement on how much you should get or how much I should get, but I didn't know you even sold the house, and you only got $30,000 for it.
I got nowhere near.
Are they getting it out of their system? Yeah? Goodbye. Your case is barred by the statute of limitations. We're done.
Court is adjourned.
He was living in a house. 2017, he sold it and didn't tell me that he even sold it.
I put all my blood, sweat, and tears into fixing that house up. He did put initial investment into it.
I should have been able to at least get half of the money from the profit from him selling that house.
Not everyone always gets a return on their investment. Sometimes people lose money on their investments, but
I don't have a brother.
I wish this didn't keep us from being brothers, but maybe we can work it out later.
Yeah, blood is thicker than water, but blood will hurt you just as worse than anybody else.
So there is a perfect example of why courts insist that you bring your actions if there's a breach of a contract, if there's an accident, if there's a claim of negligence, whatever the claim is, within a reasonable period of time. But the theory of it is that memories are fresh, documents are fresh. This guy couldn't even remember from when he signed his complaint to the story he just began to tell me. So there is a reason why courts insist that a case be fresh, because memories are clear.
They were far outside of that fresh period.
Far outside of the fresh period.
Are you having a family dispute? Go to judyjustice.tv.
Your dog was out of your control, entered her home, severely injuring her dog. into her house. There was blood all over the place. It was a mess.
This is Judy Justice. Karen Burrow-Threlkeld is suing her neighbor, Mark Seufer, for vet bills and property damage after his pit bull attacked her chihuahua.
Court coming to order. All rise.
Have a seat, everyone.
Hello, Judge. Case number 1106, Burrow-Threlkeld versus Seufer.
Thank you.
You're welcome.
Ms. Threlkeld, how long have you lived across the street from each other?
We don't live across the street from one another.
You live on the same side?
Yes.
How long have you been living in your home?
31 years.
And Mr. Seufer, how long have you been living in your house?
I closed on it May 7th of this year.
Ms. Threlkeld, are you immediately adjacent to the defendant, or are you separated by a house?
We're separated by 6 homes.
Do you happen to have a photograph?
Yes, I actually do.
Of the house? I'd like to take a look at it.
I have them according to the order.
Oh, so there's a good deal of distance between
Yes,
the two
ma'am.
houses.
Yes, ma'am. Mine's is the very last one.
This is your house?
Yes, ma'am.
Mr. Seufer, this is what her complaint is, and this is what she's asking for. Ms. Threlkeld says that a dog that belongs to you got out of your house, which is 6 houses away from hers, and somehow got into her house through a doggy door. What kind of dog do you have?
A pit bull mix,
How much does it weigh?
35, 40 pounds.
And what kind of dogs do you have?
I have a Chihuahua and 2 miniature Schnauzers.
So relatively small dogs.
Yes, ma'am.
And this is your daughter. She was involved in that incident that day. Somehow, your dog got loose from your control for whatever reason, got in to the defendant's house, inside her house. And inside her house, your dog attacked one of her dogs, causing serious injury to that dog and making a mess in the house in the process because there was blood all over the place. It was a mess. In order to try to get your dog back while this was going on, your daughter, from your house, because you had just come in, according to you, from unloading paintings that you had just bought for the house, your door was open. That's how the dog got out. You say the dog was chasing her dogs that were out in the street. I don't care. Her dogs didn't come into your house. From your house, your daughter ran after your dog and tried to get into the house by crawling through the doggy door. So far, correct?
Yes, ma'am.
You can stand up. She crawled in through the doggy door, couldn't get all the way through, but was able to reach up and open the door from the latch, which allowed the door to open. Is that what happened?
Yes, ma'am.
And when you got inside Miss Threlkeld's house, what did you see?
I didn't actually go inside the house.
Where did you see your dog?
As soon as I opened the door, she ran out towards the other dog.
Her other dog was in the yard.
Yes.
Did you see the dog that had been injured inside the house?
Yes.
What kind of dog was it?
I'm pretty sure Chihuahua.
Did you see blood?
Yes, ma'am.
How did your dog get out of Miss Threlkeld's house?
Through the door.
After you opened it?
Yes, ma'am.
So you opened the door. Did you go back out through the doggy door?
Yes.
And then you walked into the house?
No, I did not go inside the house.
The dog, when you opened the door, ran out?
Yes, ma'am.
And you saw in the house the Chihuahua with blood?
Yes, ma'am.
And then, according to you, you saw your dog go after the other dog?
Yes, ma'am.
What kind of dog was the other dog?
I have no idea.
Was it a small dog or a big dog?
Small dog.
So that was probably one of the miniature Schnauzers.
Yes, ma'am.
Did you see what your dog did to the miniature Schnauzer?
No, ma'am.
Where was your father?
He was at the gate, but he was not able to get inside the yard.
He was at the gate?
Mm-hmm.
How did you get inside?
I went through the gate because it was wide open.
Okay, so you went in through the gate. And did you see why your father couldn't get into the gate?
Karen wouldn't let him in the backyard with my sister.
Oh, so he was with your sister?
Yes, ma'am.
So he came running after your dog to her house and she wouldn't let him in the yard?
Yes, ma'am.
Okay. Was the Schnauzer injured?
Yes, but I didn't realize he...
Did the Schnauzer go to the vet or just the Chihuahua?
Just the Chihuahua.
And it's the Chihuahua's vet bills and whatever damage was done inside your house that you want Mr. Seufer to pay for.
And the doggy door, when they went...
And if the doggy door was damaged, that would have been as a result of this young lady trying to go through the doggy door.
Mm-hmm. And my pain and suffering.
The only one that's pained and suffering right now is me. Your dog was out of your control for 3 times the width of this courtroom into her house. What do you think could possibly be a defense for that?
And later today.
I ask you that question because I bought my husband a trike for a big birthday. He thought I was actually trying to kill him.
Karen Burrow-Threlkeld claims her neighbor, Mark Seufer, owes for vet bills and property damage after his bull attacked her Chihuahua. Mark is countersuing for negligence.
Mr. Seufer, you have no defense. Do you understand? You have no defense to the fact that your dog was out of your control, entered her home, injured her dog, your daughter, in an attempt to get back the dog, damaged her doggy door by trespassing in her house. Your suggestion that it's her fault because her dogs were free without a leash, if her dogs had caused any damage to your home, if they were out without a leash, I would say, well, I'm going to hear that. But even if they were outside without a leash, that's not a defense for your dog. Your dog, much bigger, much more potentially aggressive, to be out of your control and to run 6 houses down into her house. Do you understand that?
I would say that it's not 6, but 3 houses. No,
Who cares?
How
many houses separate yours from hers?
3.
3. So the dog ran 3 houses away.
Yes.
And your daughter ran 3 houses away. This is not next door. This isn't a common driveway. Was out of your control for 3 times the width of this courtroom, at least. Probably 6 out of your control into her house. What do you think could possibly be a defense for that?
Well, I think it's also relevant that police issued citations not to me, but to my neighbor.
Then they were stupid.
The animal control officer who showed
Don't
up.
tell me what an animal control officer told you. I'm telling you, you bought your home, sir?
Yes.
So you have homeowners insurance.
Yes.
In what state do you live?
Missouri.
Missouri?
Yes.
Did your insurance carrier ask you if you had a pit bull?
No.
Really? What insurance carrier do you have?
Originally it was USAA and then became Safeco. I don't know which carrier on this date was my insurer.
No, I'm just asking you, sir.
Yes.
Where in Missouri?
Veneta Park.
What's the county?
St. Louis County.
St. Louis County, Missouri. Do you have anything interesting from St. Louis County, Missouri?
I'll let you know.
Okay. She's going to get back to me. So what you're telling me is, in Missouri, insurance carriers on homeowners insurance don't ask you if you have a dog, what kind. That's what you're telling me.
Well, I've now had 2 different insurance carriers for that property, and neither asked me that question. And I don't recall them asking for the home that I sold prior to moving into that one, which was also in the same county.
I have a couple of homeowners insurance policies in several states. Every single one asked me if I had a dog and if I did, what kind. Maybe they don't in Missouri. That's a possibility. You have heard of that, have you not?
Yes.
Sure, because some insurance carriers say we're not going to cover you if you have this kind of a dog that's on our dangerous dog list, right?
Yes, there's a municipal stigma typically.
It's not a municipal stigma. It's that some insurance carriers will not insure you if you have a particular kind of dog, or they charge you an excessive premium if you have that kind of dog. You have heard of that, sir?
Yes.
Did you ever hear of a Chihuahua being on that list?
No.
How about a miniature Schnauzer?
No.
But you have heard of the pit bull being on that list.
Yes.
So you know what that means? That means if you have a pit bull or...
Sorry.
Yes, excuse me.
There's a city ordinance actually for that exact town that says section 205, 215, keeping or possessing a pit bull dog. No person within the city raise, maintain, possess within his or her custody or control of a dog of the pit bull breed.
Did you know that?
No.
She's going to read it to you again.
No person within the city raise, maintain, or possess within his or her custody or control a dog of the pit bull breed.
And it says just that one dog? Or is it more than that one?
It says pit bull breed is defined to mean any dog descending from the following bloodlines, and it lists a list of dogs.
Now do you understand?
Yes.
Okay. So that means, and you seem like an intelligent man, and your daughter is actually very truthful, for which your name is Naomi?
Yes, ma'am.
Naomi. Naomi is a truthful young lady. Well, what that means as an owner of the pit bull, A, what you're doing is against the law, according to your city ordinance. But more than that, if you have a dog that you know has been identified as potentially dangerous, you can't let a door open and let that dog get out. And there is certainly zero defense for your dog getting out and going into her house and severely injuring her dog. There's no excuse for that. And now that you know and that you're on notice that what you're doing is against the law, so that means that the police that responded to your house and the animal control officer who responded to your house, they didn't know what the ordinance said. You're not making that up, are you, Sarah?
No.
No. Do you understand, sir?
Yes.
But giving her a citation, to me, means zero. How much were your vet bills?
$1,369.49.
And what was the damage to the interior of the house?
The interior of the house is just my maintenance and cleaning it up.
No. And what did it cost to fix the doggy door?
$715.43.
$715.57. That's $2,074. Did you ask the defendant for payment?
Yes.
Did you ask him in person or by phone, or did you send him a letter, a text, a note?
I actually put a copy of the bill in his mailbox, and then on July the 3rd, I tried to talk to Mark, and he told me at that time that the police and animal control told him not to speak to me, and if I come back to his house, for him to call them, and I will be arrested. So I left it alone and filed my suit.
Smart. Do you understand where I'm coming from?
Yes. So they suggested that...
Don't tell me what they suggested to you. I'm telling you, I just took the facts directly as they were relayed from your daughter, sir. I don't know what you told the police, and I don't know what you told animal control. Did you return it?
I returned, if not more of it.
Oh, show me.
I just deposited into the account.
Were there any deposits made into the account by the defendant?
No, ma'am.
Karen Burrow-Threlkeld claims her neighbor, Mark Seufer, owes for vet bills and property damage after his pit bull attacked her chihuahua. Mark is countersuing for negligence.
Now, you have more than ludicrous counterclaim for harassment and for her negligence in letting her dogs be outside unsupervised. Judging for the plaintiff in the amount of $2,074. Good girl. Got it. Good thing to be honest. Always. We're done. I would think twice about keeping that dog, sir. It's against the law.
Court is adjourned.
Well, it did become kind of a traumatic experience.
When Mark stated that I received a citation, I didn't.
Work that amicably by avoiding each other at the very least.
Actually, I just wanted Mark to know I forgive him.
They saw the violence up close, I did.
And that we're going to be neighbors.
Do you know what was most disturbing to me about that case, and actually you earned your money on that case, is that if what he says is accurate, that both the police came and animal control, and the ordinance that you read was clear, and that to have done nothing in that scenario is actually outrageous.
Case number 1066, Godard versus Tekachenko. All parties, please step forward.
Michael Godard is suing fellow biker Elrad Tekachenko for money and property taken from their biker club.
Mr. Goddard.
Yes, ma'am.
You ride motorcycles?
Yes, ma'am.
2 wheels or 3?
2.
I ask you that question because I bought my husband a trike for a big birthday. He thought I was actually trying to kill him. So did all of our friends think that I was trying to kill him. He's allowed to ride it within the development. He's not allowed to take it outside in 2-lane traffic. Every once in a while, the family catches him coming around the garage when he thinks nobody's looking, go to the bank. I find those things a little frightening. How long have you been riding a motorcycle, Mr. Goddard?
Approximately 48 years.
Pronounce your last name for me.
Tkachenko.
Tachenko.
Tkachenko.
Let's do Mr. T. That will make it easy.
That's how I was called in school, Your Honor.
Mr. T. So you have a little group.
Yes, ma'am.
How many people are in this little biking group?
Currently, there are 5.
And Mr. T was a recent inductee in the group. He was made the treasurer of the group. Your complaint alleges that as the treasurer of this group, he misappropriated some funds from the treasury.
Yes, ma'am.
How much?
$120.77.
And you're suing him for $661. That has to do with some patches that he has.
Yes, ma'am.
Allegedly. Club patches.
Yes, ma'am.
How did he come into custody of these club patches?
As part of the treasurer's function, he's also responsible for the unassigned patches, which he would either give to people that were going to be inducted in.
Well, there are only 5 people there now.
secure
How many patches did he have?
3 main patches and other little ones that go with it. There's 3 sets. Each set contains 6 patches.
Do you have those patches?
I do, Your Honor.
Great. Would you give them to me? I want to see what he's looking at. And was he voted out? He was voted in the club, and then you voted him out of the
These are
club.
all.
Yes, ma'am.
Okay, we'll take them all.
It's just all.
We'll take them all. Perfect.
Patches.
Perfect.
Yep. Thank you.
And you're not the club treasurer anymore, is that right?
From what I understand, no.
Okay, so give him the patches back. Now Mr. Goddard has the patches. So now we're talking about $120.77. You had a credit card that belonged to the company? That belonged to the club?
To the club, yes, I did.
According to your answer, at least, you didn't have your own credit card once you ran into an emergency and you used the card for some personal expenses.
I did.
What personal expenses did you use them for?
It was like some purchases at local stores. I honestly just ran out of cash that day, so I used it.
Okay. He says you used it to the extent of $120.77.
I thought it was somewhere around $100, 120 some.
Did you return it?
I returned, if not more of it, because.
Well, show me.
I did. I just deposited into the account.
Were there any deposits made into the account by the defendant?
No, ma'am.
Then you can show me, Mr. T, proof if you have it, that you deposited money. All right.
I paid it all back, and that's why this entire episode was kind of.
You acknowledge that you used their card for about the same amount as the plaintiff says that was withdrawn, which was $120.77, which he has proof of, I'm certain. Kevin, would you get that and show that to Sarah, please? She can just verify the amounts that I assume add up to $120.77.
It looks about right, but I could do the math for you. There's a lot of little charges, like 15 or some odd charges.
You've added it up, sir?
Yes, ma'am.
120.77?
Yes, ma'am.
Yeah, 121.77.
Okay. And there's no proof of payment. So you have your patches?
Yes, ma'am.
120.77, or what else do you?
He has materials, ledgers, account books.
Okay. Are all those there?
It's all here, ma'am.
Oh, sir?
Yes, ma'am.
Now you have them back.
Yes, ma'am.
Okay. Is our work here done?
Yes.
Very good. Judgment for the plaintiff, 120.77. Everything else has been returned. Thank you very much.
Court is adjourned.
It was something that I did use.
I'm pleased with the decision. I'm glad that the judge could see the truth.
That I did repay.
If he engages in any other club, he'll do the right thing.
Obviously, I don't have proof of it, so it goes against me.
You cannot get any respect from other clubs and the general community if you show any dishonesty.
I don't expect to be part of that club in any way, shape, or form.
Just in case anybody thinks that I am not a truth teller, that was for Poppy's 80th birthday, I believe.
And I also can confirm that us grandkids also believed you were trying to kill him by getting him a trike for his 80th birthday.
Well, trying to keep the old man out.
Keep him active.
Have you been cheated? Go to judyjustice.tv.